Hey again, David Phillips, attorney. We get asked all the time, can you discharge or get rid of taxes like the Internal Revenue Service taxes in the event of a bankruptcy filing? The answer to the question is yes, in some cases that is possible, but there are some basic rules that we go by to determine whether you may or may not be able to get rid of the taxes. If you file Chapter 7, and the taxes that you're looking at discharging are over 3 years old, there is a possibility that you would be able to discharge them in that Chapter 7 filing. The 3 years is computed from the date that the taxes were due. So if it were, say, a 2012 tax return, then those taxes would have first become due on April 15th of 2013. If you get an extension to file, well, then you have to add that time period on there also. Most people get it extended to the October 15th date. So you would then begin your count in that example in October 15th of 2013 if you were looking to discharge 2012 taxes. You also have what we call the 2-year rule, and this basically means that the tax return has to have been on file for at least 2 years and that it was filed by the taxpayer, meaning that you did the tax return and filed it, and it wasn't a tax substitute return filed by the Internal Revenue Service. Basically, if you don't file your return, the service can file one for you if they get the appropriate information from your employer regarding your income and so forth. So you have to file the return, and it has to be on file for a minimum of 2 years. The final part of the initial three-part test that we look at is the assessment date, and that has to be it has to have been assessed a minimum of 240 days prior to the bankruptcy filing. Assessment merely means that the IRS, in our example, has acknowledged receipt of the tax return. They agree that the taxes are owed, and they go ahead and post that in their books that the taxes have now been looked at by one of the assessment officers, and away you go. The next one is kind of two minor rules that we go by. One, the tax return cannot have been fraudulent, meaning that you've used fake data or some sort of fake documents in preparing the return. And you can't have been willfully trying to evade paying taxes, which really goes back to the fraudulent documents and etc. But the first three rules that we went over generally cover most of the tax cases we look at, and rarely do we have any of the fraudulent type things that we were just discussing. So, answer to our question, you may very well be able to get rid of taxes in a Chapter 7 filing. We've got to look at that very carefully. I recommend that you get a copy of your tax transcript from the Internal Revenue Service. You can call the Service Center and they will give you that information. And you get one for each and every year that you're looking at possibly discharging. Usually we can review that, go through it, and the codes that are mentioned in there will give us the information we need to determine if you could get rid of that in a Chapter 7 filing. If that looks possible, we actually file a lawsuit called an adversary proceeding in your bankruptcy case. We sue the IRS, if you will, and get them to declare that the taxes are discharged. Hope that information helps. Please feel free to call me at any time if you'd like to discuss your back taxes and bankruptcy. If you prefer to email, just go to my website, phillipsbankruptcy.com, go to the contact section, shoot me an email, and I'll try to get right back with you. Thanks again for watching.